So we are covering the topic share and share capital. We'll go for this heading where we'll be discussing on right shares, ESOP, or what you call as ESOS. Okay, ESOP, and issue of shares on preferential basis. Preferential shares on preferential basis. Okay. So you remember that maximum to 50 members only we can give the shares. So that kind of a content. Already we have discussed this. Under prospectus we were discussing, you remember? Under prospectus, instead of giving to the public, we can form a group like and we can directly give to them. So that's about preferential shares. So first, right shares. Actually, we need to define what do you mean by shares. You remember what do you mean by shares? You can please turn over and refer. What do you mean by shares? Definition. Share is that money? No, it's represented in terms of money. What is that? It's a rights. Share is nothing but an interest. Bundle of rights or interest. So when you become a shareholder of the company, you get so many rights. Okay, one such right is getting bonus shares. Yes, additional shares, capital appreciation. One right is if the dividend is declared, yes, you have the right to receive the dividend. One right is I'm just trying to list out randomly, okay, not in any particular order. Randomly, I'm trying to list out. Or one more I can say here is uh, right to receive the AGM notice. See, it's your right to receive the AGM notice. And fourth one, probably under the general meeting, you have the adoption of accounts and appointing persons and all you have. And another one right is I can talk about right shares, which means it is the shares given only to the shareholders of the company. Okay, which means no outsiders will come, only to the shareholders of the company. We have gone through the heading prospectus, right? We have gone through so many types of prospectus. Can you tell me for right shares which prospectus will be used? Actually, we cannot say prospectus will be used because prospectus is something related to link with invitation to an offer. But here, directly the company will, it's like a prospectus only, but you cannot directly say that. So here the probably you remember under Indian Contract Act we are given the offer to general person or specific offer. The same like here the prospectus is given to whom? To the shareholders of the company. Okay, to the shareholders of the company. For example, Mahindra and Mahindra is giving right shares. To whom it will give? To me? No, I'm not holding shares in Mahindra and Mahindra. So the offer will not be given to me. To you? Probably. If you're holding shares, the offer will be given to you. Okay. So what it says is, we'll give you the right. See, we are not giving you the shares. Please try to understand. It's right shares mean we are not giving you the shares. We are giving you the right. If you want to buy the shares, you buy it. Else, you can give it to somebody else. We can transfer the right to somebody else. Okay. So that's right. That's what you call as transmission of rights. That can be done. So this is your right. If you want, you can take it. Else, you can transfer it to somebody else. That term, we use it as renouncing of shares. Have you heard of this one? Renouncing of shares. Myself X, yourself Y, and another one person Z is there. Mahindra and Mahindra announces the right shares. Okay, for one share, probably they'll be having some calculations and all. We are planning for one share for X, one share for Y, and one share for Z. Myself X, what I'm trying to do here is I don't want to take the shares. Okay. Also, I don't want to give it to anybody. There is another person Y who is willing to buy the shares, which means Mahindra and Mahindra will be allotting the share to directly in the name of Y. There's another person Z who's a smart fellow. What he does is he says, I don't want the share, but this is my right, right? This is my right. So what I do is I will sell this right to somebody outside, probably Mr. A, who's nobody associated with the company. There's no one associated with the company. He will give the share to A. He will not give the share, he will give the right to buy the share to. Right to buy the share is the right given to whom? To the shareholder. But he says, I don't want the right, give it to somebody else. That's what he calls as renouncing. Renouncing na அது கொடுத்துடுறது. But renouncing for no cost இல்ல. What happens? You can claim a amount. You have the scope of valuing the shares. You might have heard of this term, share valuation. Likewise, you can value the right to renounce also. Okay, there is a small calculation where you have the right to renounce of it. The Diwali season is arriving, right? Ticket booking and all started. You have booked your tickets to your native hometown, the hostelers especially. You're going to a native place, right? Amma, Appa, பார்க்கறதுக்கு, friends பார்க்கறதுக்கு. You want to enjoy. So what you're doing? You're booking in train, in or probably some are planning like this way nowadays. They book in cabs. எல்லாம் ஒரே ஊருக்கு தான் போறோம். என்ன பண்ணலாம்? We'll take a cab. We'll share and do it. Or they book buses and other things and all. Okay. If I am booking a bus, I have booked, see, during the Diwali time, that is one day before Diwali, if you book the ticket, normally the ticket charges 1,000 rupees in the omnibus. But what you're doing, you are not planning. The one day before the Diwali, you are planning to go. Now the ticket charges 5,000 rupees. So what you're doing is, ஊருக்கு போறோமோ இல்லையோ book பண்ணிடும் bus. So how much you have paid? 1,000 rupees. Okay. Yourself X. You planned, but due to some unavoidable circumstances, ஒன்னா கேக்குறீங்க என்ன unavoidable company law class தான். Due to unavoidable circumstances, what you have done is you cannot plan to go to your native town. So what you are doing is you are giving this bus ticket to your friend Y. Okay. So your friend is going to visit. If Y buys the ticket one day before Diwali, what's the charge? 5,000 he has to pay. But you already have a ticket for 1,000. Okay. Now see, he is going to get 1,000 rupees means he is going to get 4,000 rupees extra amount, right? So what you are planning is, I bought it for 1,000. Long back I bought it. I will give this, right? You take the bus, I'll pay extra 500 for. Whose seat is this? Yes, seat. நான் தான் சீட் துண்டு போட்டு வச்சிருக்கேன். ஓகே, ஆனா நீங்க டிராவல் பண்றீங்க. அந்த துண்டு போட்டு வச்சதுக்கு எவ்வளவு? 500. Already I have invested the shares in Mahindra. I'm the shareholder. That's why I have the right to buy the shares. And they are giving the shares only to me. It's not a bonus share. It's not other normal IPO or FPO or other secondary market you're buying. You're directly buying from the company. Okay. So in this case, this 500 rupees is not the seat charges, the bus charges, but what? Because you bought the right, it's given to you and you're paying the charges. So that's what you call as renouncing, and that renouncing also has a value. Okay, so this is about right shares. So it's a right to the existing shareholders. I request you to highlight this one. They may be confusing you. Is that right to the existing members? Actually, when we talk about a right, we have to talk about the right of the members only. But only if you hold the shares, only you can get it. So if you are an existing shareholder, when the company wants to increase the share capital. So the company is planning to increase the share capital. So instead of going for a third party and checking for everything, you are planning to give the shares to your members itself, because the members, they already know about it. So I was asking this point, you remember? We'll not use the term prospectus. Instead, what we'll use? Huh? Uh-huh. No. What will you use? You can turn back. You can turn back and reform. You came across this term, you remember? Letter of offer. Letter of offer is the company directly giving to whom? To the shareholder. That's why I said it's not prospectus, but it's prospectus. Prospectus means what? Linking to invitation to an offer. Letter of offer means what? Directly we are offering to the shareholder. If you want to accept it, else give it to somebody else. Okay, to whom you can give? To anybody. Need not be a shareholder. To anybody you can give. So this is exactly not like prospectus. It's of issue of shares. That's why I tried to link with prospectus. You cannot say this is prospectus. Instead, what word do you use? Letter of. Okay, make yourself clear. This is what important. So when we say the right, also you get the right to accept or renounce it, not a free cost, with the value. Okay. So we'll come across here something called as We'll go for the next content. Okay. Something called a stock option plan or stock option scheme or something like that. See, now Mahindra has introduced this stock option plan. Actually, they have not said this as option. They have said this as ownership plan. நல்லா இருக்குல்ல? Stock, that is employees, stock ownership plan. Why the employees need to be just employees? Let them be owners. And first time in Indian history for the company that this Mahindra is issuing the shares, that is issuing or asking to buy the shares, not for the general employees, even for the shop floor. I shared that link to you. No link share for no. Uh, even for the shop floor employees. What do you mean by shop floor employees? கூட்டுறவங்க, பெருக்குறவங்க. So the caption was like this, I remember, from sweeper to the management. Usually the employees means a set of employees will be covered. They'll be mentioning who will be covered and who will not be covered because they cannot provide loan for buying the shares and all. So many conditions are there. So one person wants to become the owner of the company means they need to have some qualities like if they go for employees. First time Mahindra and Mahindra has gone for issuing shares, employee stock ownership plan for shop floor employees also. We don't know how many will buy. It's crossing around some 18 or 19 crores, I think. I'm not very sure. Remember the value? I don't remember. Okay, fine. So it's about stock, employee stock option plan. Why we say it's option? We leave it to you. If you want to take it, let's leave it off. Okay. What's special about this employee stock option plan? The price will be not current price. That's for the future, and also it will be predetermined price. Today, my market price of the share is 420 rupees. 420 money. 420 rupees. In future, we expect that it may go for around 600. Today, I tell my employees, I'll fix a price. See, predetermined price. I'll fix a price for today. In future, probably how long? After 1 year, you buy the shares. That period will be given. Within 1 year, you have to buy the shares or something like that. So within 1 year, you buy the shares. Okay. After 1 year or within 1 year, within 15 months, it will be. At what price? For 450. Yes, nice, we can do it. Why not? See, today's price is 420. You're going to buy it in future, but we're going to fix the price today itself. Probably it might be expecting, we might be expecting to rise to 600, but we are giving you for 450. Okay. And who will be the eligible employees? Please highlight this is an important list. Who will be the eligible employees? He should be a permanent employee in or outside India. So he's not currently working in India. He's outside India only, but working for our organization. Yes, you can give the shares to him. A director, which includes whole-time director, excludes an independent director. Independent director is never an employee. Okay, independent director is completely out of the team. Okay, probably he might be a director or employee in the holding company or subsidiary company. Again, holding and subsidiary in and out of India, but does not include an employee who is belonging to a promoter group. Okay, we have Anand Mahendra. Okay, he belongs to a promoter group. We cannot say he's an employee and allot the shares to him. Okay, already he's holding a big stake. Okay, we cannot say he's also an employee of a company. Let them allow that. No, you cannot do that. That's not covering under this employee definition, even though he's employee of the company. Okay, that will not be covered. So he's an employee who's a promoter or a person belonging to the promoter group or a director who either himself or through his relative or through any body corporate directly or indirectly holds a more than 10% of the outstanding equity share. What do you mean by outstanding equity share? Huh? Sorry. No, no, no. Unpaid is unpaid. Paid up capital you talk about. I am talking about equity shares only, but outstanding. Yes, you might be knowing all these. Just try. What do you mean by outstanding equity share? What do you mean by outstanding? Leave of equity and all. What do you mean by outstanding? Yet to be received. Okay, the equity shares yet to be taken as equity shares. No, no, it's not related to payment at all. It's not related to payment. Preference shares is there. Okay, cumulative, convertible preference shares. What do you mean by convertible preference shares? It will be converted to equity. Okay, there's a director. Okay, director. Let me come again this point. Here is a director who either himself, okay, or through his relative, director is Mr. X, his relative, Mamnar, Mamiya, Chitappa, Mr. Y, or through any body corporate, through a company, probably A Limited, directly or indirectly, he's getting some benefits means all put together, if he holds more than 10% of the outstanding equity share, probably as of now, he has the equity of around 8%. Okay. Preference, he has some 3%, or let me have it as 2% itself. I cannot take this preference share because what they say here, they're asking you to take only equity. But what they say here is outstanding equity share, which means in future this preference share is such a nature given, it will be convertible in nature, which means what? Convertible to equity in the future. Convertible in nature. So whenever you find this preference, please add a word, either it will be convertible or non-convertible, cumulative or non-cumulative. Okay, redeemable or non-redeemable. So all these, so this will define the nature. Okay, so if it is a convertible preference share, you should consider this as what? Equity share itself. That's what they say, outstanding equity share. So totally how much he holds? 10%. In case, for example, here, preference share is there, which is 2%. Convertible preference share, this is nothing is mentioned. Non-convertible. This is convertible preference shares, he holds 1%. How much totally? As per this definition. Don't add and tell the total. How much? 9%. Because this will not be considered for calculation. How much he holds now? Outstanding equation, only 9%. Then he will be included. See, this list is for not including. This director, who either himself or his relative or any body corporate holds only 9% of the outstanding equity share, so he can be given this employee stock option. Okay, he can be given this employee stock option. And obviously, you have to pass a resolution. So, public company is a special resolution has to be passed, and private company ordinary resolution is sufficient. Okay. So, ESOS is over. Let me go for next content, issue of shares on preferential shares, preferential basis to any select person or group of person on preferential basis. Somewhat we have done with prospectus, right? Preferential shares. Okay. Does not include shares or other securities offered through public issue, which means if you're offering to public issue, it will not be considered on shares issued on preferential basis. It will not be with respect to right issue. It will not be respect to ESOP or ESPS, employee stock option, stock plan and scheme. Issue of issue of sweaty equity shares should not be considered. Bonus shares should not be considered. And you remember, GDRs and ADRs should not be considered. Other than these, you can consider as private placement basis. You can consider this as private placement basis. This share is what you call as issue of shares on preferential basis. You can correct it. This share is what you call as issue of shares on preferential basis. Is it okay? Applicable provision follows from section 62. Further issue of share capital. When you can issue at any time. For what purpose you do it? While you propose to increase the subscribe capital. I want more of capital inside my company. I can go for debt capital or equity capital. But I don't want to go for debt capital. Let me go for equity capital as you can do. Okay. All put together we'll discuss here. To whom? In case it is a right issue. Okay. To whom you can issue? By to holders of equity shares. How you do it? Will exactly is not prospectus, but the logic somewhat behind here is working as a prospectus. So you give this as a notice. Okay. So holders of equity shares at the date of the offer and by a letter of offer you give it. The notice, in the notice you have to mention the number of shares you are offering and the time limit will be there. 15 days to 30 days is the time limit. Before that, if you want to say no, yes, you can decline it. If you're not saying anything, it's accepted as decline. See, if not accepted, it's considered as deemed to be declined. Okay. And it's a deemed right. You have to provide it in articles of association if you don't want to give this right. Else it's a deemed right. Who can exercise this one? By the concerned person only. By the concerned shareholder only can execute it. And right to renounce the shares will be offered to or in favor of any other person. Any other person. Please highlight that person need not be an investor of the company, a shareholder of the company. He can be any person. Is it okay? And this notice should contain this right saying that it is renounceable in nature. Disposable of shares after the expired time or on receipt of the notice declining the right, you can dispose the shares and by the board of directors in the manner not disadvantageous to the shareholders. So who can do it? You need not go for passing the resolution. First, it has to be taken care by the management. So they can directly do it. ESOS and ESOP, yes, by the employee, sorry, to the employees, subject to special resolution and conditions described. Probably after the session, you can just have a check on Mahindra's and Mahindra's ESOP plan, okay, ownership plan. Okay. Next is issue on preferential basis on any person. Please highlight. Can be any person, but should be authorized by special resolution, whether it includes the above persons or not. Probably that special resolution itself will contain the complete agreement saying all these persons will be included in this preferential shares. Okay. So either for cash or consideration other than cash. So cash means not exactly liquid cash. Okay, everything has to be transferred to the account only. Price determined by the valuation report. Okay. And who will be providing this valuation report? It will be provided by the registered valuer and he will go for the compliances given as per the law and he'll be giving a report. He will value the shares and he'll be giving the report. Okay. So after doing all this, now what you do? You go for dispatching the notice. How you dispatch the notice? CA students. We have done this concept, notice service of notice by post. Through registered office, you have to registered post. Else, sometimes in some other act, they'll be mentioning either by registered post or speed post. Companies Act clearly acknowledges mail communication also. So e mode or some other mode having proof of delivery. They will be having something called as timestamp. Okay. To whom? To all existing shareholders when at least 3 days before the opening of the issue. Okay. Then subsection 3, for whom it is not applicable. If you want to increase the subscribed capital by way of conversion of debentures or shares, what related preference shares can add here preference shares into shares. For them, it's not applicable. Okay. And such debentures or loans shall be authorized by special resolution. Okay. Yes, government power. Always when government provides a loan to the company or provides any support like then government plays an important role. We have to be ready. Whenever the government issues some order, you have to follow that order okay, blindly. So sometimes what the government will do here is it will make to convert the debentures and loans raised from any government. Probably state government has state government or central government has given a loan to the company. Okay, the government will say don't replace the loan. That is, don't repay the loan. Instead, you convert that land, loan and debentures to what? Shares. It can do it. Okay, it has the rights. Which means this section provides the right to the government. This is the empowering section. And the terms and conditions, everybody will be fixed by everything will be fixed by the government, even not included in the agreement. Even in the loan agreement is not included, they will be considering it. And the company shall appeal to the tribunal. If company is not satisfied with the terms and agreements of the government, then the company can appeal to the tribunal within how many days? 60 days from the communication of such order. And the tribunal, probably after hearing the company and the government side, it will pass such order. So once the tribunal has passed the order, then we have to listen to that. No other go. Okay. With respect to subsection 5, the government, when checking all these, it will check what's the financial position of the company, what's the term of the issue of debentures or loan, what's the rate of interest payable, and other matters as it may be considered necessary. With respect to subsection 6, where no appeal has been made or dismissed with, the MOA stands altered. Please highlight. Often repeated question. இந்த கொஸ்டின் எங்க இருந்து கேட்டாங்கன்னு நம்மளால கண்டுபிடிக்க முடியாது. Just like a one line question would be. Okay. Where no appeal. Who will make the appeal? This section 62 is giving power to whom? Power to whom? The company can appeal to the tribunal. Okay. Company can appeal to the tribunal. Okay. Where no appeal has been made or appeal has been made and it's dismissed. Please try to understand. As a company, I did not make the appeal. One case. Second case, I made the appeal, but the tribunal has given the order in favor of the government, which means it was dismissed. In that case, the MOE will stand altered. Okay. And the authorized share capital shall stand increased. How much? With respect to the converted debentures. For example, my company's authorized capital is 15 lakhs. Okay. I want to increase the capital for another 3 lakhs. What I have to do? Leave of this case. I'm asking the general case. My authorized capital. What do you mean by authorized capital? The capital mentioned in the MOA. My authorized capital is 15 lakhs. I want some capital inside the business. I'm planning for expansion or something like that. So I'm asking to raise the capital for 3 lakhs. So what will be the capital now? 18 lakhs. What will be the procedure behind? Alteration of MOA. What will be the procedure behind? What you have to do? First, you have to call a board of directors meeting. Then you will fix a AGM date and you get the shareholders resolution to be passed. Then you can go for increase of share capital. Okay. Then you can go for increase of all this has to be done. But what it says here is once the appeal has been made or it is being dismissed, okay, what happens? The MOA stands altered, even though you have not changed the MOA. Already, the share capital of the company is 15 lakhs and is fully subscribed and fully paid. Now, what the government is doing, you borrowed 3 lakhs from me, right? The government says to the company, you borrowed 3 lakhs from me. Now, I'm converting this debentures or loan to what? Capital itself. Now, what should be the capital here? 18 lakhs. Okay. But you have not increased the capital. It's already 18 lakhs, then it's fine. It was only 15 lakhs, but now 3 lakhs is being increased, that's cumulated. What happens here? It becomes 18 lakhs. What law says? Usually, when you go for increasing this capital, you have to go for all the procedures followed. But here, government itself has given this order, which means what? Through the tribunal. So you need not go for all these procedures. It says the MOA stands altered. Okay, and the authorized capital shall also stand increase. To how much? To the converted debentures or loans? Probably part of. What do you mean by part of? Government has provided loan for 3 lakhs. Now government says only for 2 lakhs we convert debentures to shares. Remaining 1 lakh you repay. So now 15 lakhs plus 2 lakhs only will be considered, which means 17 lakhs will be converted as authorized capital. Okay. Please make a note here. It's mentioned here as authorized capital. Not paid up capital, not subscribed capital, not issued capital. What they are mentioning here? Authorized capital. So two things are happening here. One is MOA stands altered. Second one, the authorized share capital shall stand increased. Okay, please make a note for. So that's about right shares, ESOP, and see how you can understand law in a better way is treat each and every line as different words. See, when I was discussing this one, automatically you have to make a note whenever you find this shares or share capital. When we say shares, you can understand. You have to check whether it's equity shares or preference shares or just shares. Just shares means what? Involves both equity. Likewise, whenever you find the share capital, please check is issued or subscribed or authorized or equal to nominal or paid up or unpaid. Everything has to be checked. Okay. So here, because it is saying or related to MOA, the share capital will be what? Authorized share capital. Okay, so you have to learn law in such a way that you break into different words and check. Okay, you'll understand it a better way. So now let me go for issue of bonus shares. Actually, bonus shares, we say that it's a capital appreciation for the shareholder. I invested in shares. Usually what I do, I check on return on investment. Okay. Return on investment, usually we see in terms of dividend, which is a revenue appreciation. And when we go for bonus shares, we call this as capital appreciation. Okay. So what is the bonus shares? Please highlight issue of unissued shares of the company to the members. Please highlight. Issue of unissued shares. When a share comes to existence, only when issued, right? Remember? When we say about shares, means only after allotment it comes into existence. So when we say share, actually completely put together a share capital, we are going to break into different shares. Here, how they define bonus share is nothing but issue of unissued shares. So it's already I have given to somebody else, and that I'm giving it to you. No, not that way. To nobody I have given it. Now I'm giving it to you, which means it's the first way of directly giving to the members. So issue of unissued shares of the company to the. So we'll go for the applicable provision, section 63, with respect to issue of bonus shares. Subsection 1 says issue of fully paid up bonus shares to his member in any manner. Request you to highlight, you cannot pay partly paid up shares. என்கிட்டயே பணம் இல்ல. நீ ஏதாவது தருவியான்னு வெயிட் பண்ணிட்டு இருக்க. இதுல வேற நீ ஷேர் இஷ்யூ பண்ணிட்டு என்கிட்ட பணத்த கேட்பியா? நோ. Issue what? Fully paid up bonuses. Okay, you cannot issue a partly paid up bonus, which means you cannot keep a liability on the member. You buy a share in my company. Okay. What is the face value? 10 rupees. And you have paid 7 rupees, which means there is a 3 rupees liability to you. I issue a bonus shares, which is 7 rupees, sorry, 10 rupees. 9 rupees is paid. I say that whenever I ask you, you have to pay 1 rupee. What you will be saying? Share See, this is a fact. See, as an investor, I am willing to buy shares in your company means I have to follow your law. Now, you're the company, you're willing to give the capital appreciation to the shareholder means you have to follow our law. Okay, which means what? You should not ask us 1 rupee in later case because I'm not paying in a situation to pay the amount. So you should not give the liability to me. See, whenever it's nothing but a promise, right? Liability means obligation, promise. So whenever I give a promise, it should come from my side. The concern should be from my side. You cannot force me to take the liability. So whenever you go for issuing the shares, particularly bonus shares, what it happens? You have to issue as fully paid up shares. Okay, so fully paid up bonus shares to whom? Members. What's the difference between right share and bonus shares? There it is existing shareholder. Here it is members. Okay. See, you're going to issue fully paid up shares. Fully paid up shares, you will not get the amount, you will not get the cash from the shareholders. So you have to make some entries, physical entries inside. So from where you're going to make it? From the free reserves. So sources of issuing the bonus shares from the free reserves or the securities premium account and from the capital redemption reserve, CR. You have to create a CR. Okay, capital redemption reserve. No issue of bonus shares shall be made by capitalizing the reserves created by the revaluation of assets. So when we talk about the free reserves, we should not consider the assets, revaluation reserve. Okay, right? With respect to subsection 2, issue of bonus shares is capitalizing its profit or reserves in case it's capitalizing its profit or the reserves. It should be authorized in articles of association. If it is not authorized, what do you have to do? Give the authorization, amend the articles. First one. Second, board of directors has to make the recommendation. Please highlight. It's a beautiful point. Two things happens when you talk about profit. Okay, already we have discussed this. Part of the profit given to the shareholders, we call it as dividend, right? Part of the profit given to the employees, we call it as bonus, not bonus shares. Bonus paper triangle, festival bonus, that bonus, this bonus, profit related bonus. Okay, to whom? Employees. Part of the profit paid to the management, called as management remuneration. In short, we'll call it as MR. 11% of the profits will be given to the directors and okay. And it's actually not part of the profit. If the profit, I want to make it as capital growth for the company. பணம் வெளியில போகக்கூடாது. At the same time, I need to give some appreciation to the shareholders. So we are planning for capital growth. That's what we call as bonus. Okay. Now let me go in this angle. These four terms are okay, right? Now let me try in this angle. Dividend, what happens? Cash goes out. Okay. Bonus, what happens? Cash goes out. Managing remuneration, what happens? Cash goes out. Here, so probably we want to give the return on investment as a capital appreciation to the shareholder, but money should not go out. So what we are planning? We are capitalizing the profit. We are capitalizing the reserve. There are so much of reserve pulled up in my account. Under reserves and surplus, I have free reserves. So much of reserves pulled up. At the same time, I should not give it outside. It should be within the company. I should not, because in later period, I cannot go for asking the shares, right? So what I'm planning here, let me capitalize this reserve. Now come again with this point. Make yourself sure whether you're comfortable with this line. What it says over here is capitalizing its profit or reserves. When it comes directly dealing with company's money, please highlight. When it goes for directly dealing with company's money, who is having the complete right? Board of directors. Board of directors is the only authorized person to go for dividend and also for not declaring dividend, proposing dividend. Who has the right to declare the dividend? Only the shareholders in the annual general meeting. Okay. When the board of directors recommend a dividend, it will be declared in the shareholders meeting. Likewise, when the board of directors recommend for bonus shares only, you can go for issuing the shares. So you cannot go and ask, I have invested so much. Sometimes usually this happens. Okay. I have invested in a company ABC Limited for 10 years. Okay. You came yesterday. You bought the share yesterday. Today you're getting dividend. Tomorrow you're getting bonus shares. Okay. எனக்கு உங்களை பார்த்தா எப்படி இருக்கும்? உங்களை பார்க்கவே மாட்டேன். Okay. See, actually, this type of vengeance will not be there in this concept because company is such a way defined. Company when wants to give, company means through the board of directors. When wants to give, will give it. எவ்வளவு நம்ம தரக்கூடாது 10 வருஷமா இருக்காங்க அப்படியெல்லாம் இல்லை it cannot hold it that way. It cannot do it. That's why even not giving a general notice, annual general meetings notice to one shareholder will invalidate the meeting. தெரியாம கூட பரவாயில்ல தெரிஞ்சே ஒரு ஷேர் ஹோல்டருக்கு தரக்கூடாதுன்னு சொல்லிட்டு தெரிஞ்சே தராம இருந்தா எவ்வளவு இயர்ஸ் கழிச்சு ஆனாலும் அந்த மீட்டிங் வந்து இன்வாலிட் ஆகும். If that has been found for this respective person, they have wantedly not given who the board of directors when 20 years ago. Is that person alive? No. Board of directors alive? No. Nobody are alive. The meeting is not valid because it's done wantedly. This is the right. Likewise, what they say here clearly is board of directors should make the recommendation, which means not, it's not your right. Please try to understand. It's not the shareholders' right. Only if the board of directors recommend, then only you can go for getting the dividend and bonus shares. If they're not recommending, then no issues, leave it on. Okay. And not only that, please check here. No default has to be made with respect to payment of principal, interest with respect to fixed deposits or debt securities issued by it. Not only that, no default should be made with respect to statutory dues of the employees. PF pay panno, gratuity pay panno, bonus pay panno, avungalukku pay panni mudinga. Okay. And convert the partly paid up shares to fully paid up. If any outstanding, please highlight. This is not with respect to bonus shares. Before issuing the bonus shares, already there are some persons to whom you are going to issue the bonus shares. To the members. Okay. Already the members are the shareholders of the company. They are holding shares. How much they are holding the shares? Probably some 10,000 shares are they are holding. And for each share, 3 rupees is unpaid. See, from the 10 rupees, 7 rupees is paid, 3 rupees is unpaid. Already they have the liability of 3 rupees. என்ன சொல்வீங்க நானே 3 ரூபாய் கொடுக்காம உட்காந்துருக்கேன் நீ வேற ஷேர் தரீங்க முதல்ல அதை க்ளோஸ் பண்ணு. See, first you should not have the liability with the members in. So first you close this 3 rupees share. See, now come across this point, E point. Convert the partly paid up shares into fully paid up if anything outstanding is there on the date of allotment. So it's not only that you're going to issue the fully paid up bonus shares. You're first going to convert the partly paid up shares to fully paid up, then go for issuing the fully paid up bonus shares. So all this has to be done. What are the things has to be done? If anything outstanding is there with respect to fixed deposits or debts, you close that. And any statutory dues spending, close that. Employee salary தரல முதல்ல salary கொடுங்க அப்புறமா பார்த்துக்கலாம். That's what they mean. And statutory duties you have to complete all this. Bonus is a mandate. See, we were discussing this one. For one person, it will go as dividend, the profit. For one person, it's going as dividend. For another person, it's going as bonus. For whom? Employees. For another person, it's going as managerial remuneration. Only when the dividend is recommended by the board, then it will be declared in the AGM. Then it is a liability for the company to issue, to give the dividend. But what about bonus and managerial remuneration? Even though there is no profit, sometimes a resolution is passed where the managing director chairman will be getting the salary. Okay. What about bonus? Any idea about bonus? You might have studied in tax. Not much in detail. At least we have some knowledge about bonus, right? What do you mean by bonus? What do you mean by bonus? The employees are working for the organization. So we'll give something as a percentage of profit. Okay. Usually the bonus will be given as 8.33% to 20%. Probably you might have heard of this percentage. 8.33% to 20% will be given as a bonus. Okay. Each and every year, probably first 4 or 5 years, the company did not give the bonus. From the date of incorporation, first 4 or 5 years, it did not give the bonus. But after that, surely Whether it's going to give the dividend or manager remuneration, that's all secondary. It has to give the bonus to the employees. See, 8.33% or 20%, on what proportion? On profit you're going to consider. If there is no profit, you can keep this pending for 4 years, which means carry forward. You can have this, and within 4 years, you have to close this one. So when a company has entered into this provision, so that's why we say whenever somebody comes for consulting, in my company, I have some 18 employees. So we need to increase this number. How much you want to increase? Maximum one or two only you can increase. Because if it crosses 20, you'll be attracted by payment of bonus act. Payment of bonus act says once it is crossing 20, we have to pay the bonus. How much? 8.33%. Okay, along with the salary, this becomes mandatory. But dividend is not that case. See, that's why we say board of directors recommends the dividend. Even though there is profit, board of directors only should recommend, then only they can go for giving the profit. Else they cannot. Okay. So it will comply such other conditions. The subsection 3, the bonus share shall not be issued in lieu of dividend. See, this year I gave the dividend, so why I should give the bonus shares? I need not know, the board of directors cannot decide in such a way. Okay. So instead of dividend, you cannot have the word instead of dividend. You can give dividend, you can give bonus shares. Yes, yes, can you just go share certificates? Actually, for public companies, mandated that you have to maintain in demat form. So in physical, not in physical copies. Earlier, even for private companies, we have this provision where you have to give the share certificates once they become the shareholders of the company. Even though you don't hold the share certificates, you are the shareholder of the company. Why? Because you have bought the shares. Are you a member of the company? Need not be, because your name is not entered in the record. Okay. Applicable provision follows from section 46, certificate of shares. 46 subsection 1 says certificate will be issued under common seal. Is common seal mandatory? No, it's not mandatory. So if you have a common seal, issue under common seal. If there is no common seal, then it will be signed by two directors, or director and a company secretary. Which means if there is a full-time company secretary in your company, then a director and company secretary has to sign. Specify the number of shares held. It's a prima facie evidence. What do you mean by prima facie evidence? There's two things with respect to evidence. One is prima facie evidence. One is conclusive evidence. MOA, AOA, certificate of incorporation, and all conclusive evidence. You say this is a private company or public company. How you say this? Any company. How you say this? Because we have the certificate of incorporation. 7 members are required to form a public company. எல்லாம் 7 பேரும் சேர்ந்து மண்டே போட்டாங்க. Is the company existing? மண்டே போட்டாங்கன்னு சிரிக்கிறீங்க. சோகமா இருக்கணும். Is the company existing? Yes. You say this is conclusive evidence. Myself, why? I hold 10,000 shares in a company. I sold it to you X. How much? All the shares, but I have the share certificate. The share certificate says under my name, okay, it's given to me. How many shares? 10,000 shares and the numbering of the shares because it will specify the number of shares and everything. Tell me, am I the shareholder? No. But the certificate shows my name, right? Okay. You have your 10th mark sheet, 12th mark sheet. Okay. Whose name is there? I hold it in my hand and say it's my certificate. Will you believe it? No. The certificate is issued in your name. It becomes you're the qualified person. Okay. That's a conclusive evidence. This is also a certificate. I hold the certificate. It says in my name. But what happens? I have sold the shares to you. It's not a valid certificate, right? So we say this is prima facie. Prima facie means prime face of the document. You can please make a note of it. Prime face of the document. Document பார்த்தா என்ன இருக்கு? Shares என் பேர்ல இருக்கிற மாதிரி இருக்கு. So as per the document, it is in my name. That's it. Is that conclusive? Need not be. Is it okay? So it's meant for physical shares where the title of the person to such shares will be mentioned. But when we go for demat shares, this follows from section 46, subsection 4. Depository will maintain a record and that will be considered as a prima facie evidence. Okay. So we have this NSDL and CDSL. These two companies are holding the shares on behalf of me. So they will be called as the legal owners of the shares because their name is written. They'll be called as legal owners. Myself X, I hold an account in NSDL. Yourself Y, you hold an account in CDSL. There is somebody Z who hold account in NSDL and CDSL, whatever it is. Okay, in this case, X, Y, and Z are the beneficial owner of shares. Please make a note of it. So we'll have this two concepts. One is legal owner and one is beneficial owner. NSDL and CDSL are the two companies having the legal ownership. When we talk about demat shares. Is it okay? Right up? Shall I take over? With respect to subsection 2, duplicate share certificate can be issued when it is lost or destroyed or defaced or mutilated or torn or surrendered to the company. Then subsection 3, it should be in prescribed manner to issue the share certificate or duplicate share certificate. All the details has to be entered in the register of members book and other related matters will be entered also. And if a company is issuing a duplicate share certificate intentionally to defraud, means company will be liable to a penalty whichever is higher of 5 times of the face value to 10 times of the face value involved in the duplicate share certificate or 10 crore rupees. Depends on whichever is higher. Okay. And officer in default will be liable under section 447. So this is with respect to 46, section 46. Shall I take over? Section 55. This I have to go in detail. Issue and redemption of preferences, somewhat related to buyback. Buyback is related to the concept for equity shares. This is a concept related for preference shares. So with respect to subsection 1, please highlight often repeated question. Issue of irredeemable preference share is not allowed. Probably by just to classify, I can say redeemable and irredeemable. But what law says is subsection 1 says is irredeemable preference shares cannot be issued. Okay. So if the preference share name, probably you can find it in the balance sheet, notes to account, 11% cumulative convertible preference shares. It's understood it's redeemable only because this section says you cannot issue a irredeemable shares. Okay. With respect to subsection 2, issue of redeemable preference shares can be done only if authorized by the article of association. When we say redeemable, it has to be redeemed. Uh, uh, from when? That is from which date to which date? Before 20 years from the date of issue, subject to the prescribed conditions. Proviso. If you want to redeem after 20 years, means yes, you can do it, but not for all the companies. It's allowed only for companies dealing with infrastructure projects and other things. But what happens is probably if you are planning to redeem after 25 years or 30 years, probably 20 years to 30 years. Usually what we'll do is we'll have some escrow account created and each and every year on an annual basis, I'll be depositing the percentage of it. So that at the end, probably it's for 30 years, means at the end of 30 years, I'll be getting that up. Just imagine that I'm going for 10 crore preference shares. Up to 20 years, by law, you have to redeem it. But because of this infra project, I'm extending for another 10 years. Okay, which means with that extra 10 years, I have to make some percentage on annual basis. For each and every year, I'll be depositing 1 crore. Okay, so for 10 years, it will become 10 crores. This is one way of calculating. There you are not giving importance for time value of money. Probably you do it in your mind. We have this in CA group 2. I'm not sure. You may have it. So either you go as uniform basis, 1 crore for 10 years. One. So from 21st year you will deposit 1 crore. 22nd year you deposit 1 crore. Likewise, you go till the 30th year. At the end of the 30th year, you'll get all the 10 crores in your account. Either you go this way or this 1 crore which you deposited in the 21st year is not the same as 1 crore which you're depositing in the 30th year. So what happens here is you'll get more amount because the interest and time value of money will be differing. That's why this will not be 1 crore, it will be less than 1 crore. So applying the time value of money concept. Okay. Actually, it will be provided in the question, I think. Okay. Proviso further. So where you go for sources of redemption out of profits of the company, or you can go for a fresh issue of shares. It is somewhat similar to discuss with buyback of shares. The same concept here. Out of the process of the fresh issue of shares made for the purpose of such redemption. Okay. Redeemed unless the shares to be fully paid. No such shares shall be redeemed unless they are fully paid. Which means if they are partly paid, make it as fully paid, then make it go for redemption. And if it is out of profits, to whom these profits belong to? to the equity shareholders. Okay. But you're taking out that profit. So what you have to do is you have to create a CRR and transfer to the CRR. Okay. If redeemed out of profits. So how much you transfer? Only the nominal amount of the shares. You will be redeeming by premium. So probably 10 rupees is the face value, nominal amount of the preference shares. You will be redeeming for 15 rupees. You transfer only 10 rupees to the CRR, not the whole amount. Okay. So CRR is treated as paid up share capital with respect to provisions of reduction of share capital. All these concepts are. Okay. Next, D, reduction on premium. Yes, you can redeem, but you have to comply with the concepts of accounting standard following from section 133. From when you go for a reduction on premium, what is the source? You take it out of profits. Before profits means you have to calculate before redemption, and reduction on premium on or before the commencement of the act has to be checked. In case you are doing after, that means it can be done with respect to profit or securities premium account before on or after commencement. So this is after commencement of the act. This is on or before commencement of the act. On or before commencement of the act, you take it as directly reduction of premium. Here, premium may be taken out of profits or securities premium. Okay. In case you're not following this one, so directly you go for out of profits or securities premium account before such shares are redeemed. And so here we consider other than complying 133 because this is not following accounting standards. Okay, so you can just go through this one. Let me continue. With respect to subsection 3, when you go for issuing further redeemable share, often ask the question, let me go line by line. You're going to issue further redeemable shares inclusive of the dividend amount. Okay. What do you mean by further redeemable shares? The redemption date has come, the due date has come. It's the time for you to redeem. But what happens if you cannot redeem it? Because you need to have the cash amount, right? It's not possible for you to redeem. You're not giving the dividend also. You're not able to make the payment also. What you're doing is that amount you're issuing as further redeemable shares. Okay. This is the due date. You have to make the payment. Let me have a figure for 10 crore rupees. The due date has come. We have to redeem it. Along with the interest, not interest, sorry, along with the dividend is now 11 crores, for example. It's now 11 crores. We have to give the 11 crores. But you don't have cash. The company does not have money. So what the company is planning is, let me give this 11 crores as what? Preferential share issue. Okay. Let me give this 11 crores as preferential shares. Now read this line. Issue of further redeemable preferential shares. We'll check the position of the company. If the company is in a position that it cannot redeem or pay the dividend also, then we'll name the share as, please highlight, you're going to name this share as not irredeemable, unredeemable. Please highlight. See, probably in future when you go for referring the balance sheets, you come across all these terms. We have no such concept called as irredeemable. Okay. Just for classification sake, we'll be using as irredeemable. Okay. What they say here? Unredeemable, which means what? Unable to redeem. Unredeemable preferentials. So what we do is we go for taking the consent from the shareholders. From whom? We need to get the resolution passed. From whom? 3/4 of the value, not the number of shareholders. Here we talk about the shareholders with respect to preference shares. Usually, when we say shareholders, we talk about the ordinary equity shares. But when we say about the shareholders, we are directly dealing with preferential shareholders, right? So we go for preference shareholders. So from the holders of 3/4 of the value of preference shares, and we get the approval from the tribunal, which means they will be making a petition, and the word redeemable preference shares are deemed to be redeemed. Please highlight. Once this 11 crores worth redeemable preference shares are given means, what happens to this 10 crores? It's redeemed. So you should not talk hereafter about the 10 crores. You should talk hereafter about the 11 crores only. And what's the redemption period? Maybe up to 20 years. It's a very beautiful concept. Nariya company didn't watch it. Okay. Proviso, the tribunal while giving approval may order the redemption for those who have not given the consent for the further. Sometimes only 3/4 of the value is enough, remaining 1/4 out of this 10 crores worth shareholders, 2 crores worth shareholders are not giving the consent. But what the tribunal is saying, others have said, okay, you have to follow it. Okay. And explanation deemed not to be an increase or reduction in share capital. Please highlight. deemed not to be an increase or reduction in share capital because it has now increased to 11 crore, right? Instead of 10 crores. We should not consider this as increase or reduction in share capital. So sometimes what happens is seeing just the MOA or seeing just the balance sheet, you will not understand many things. Only after looking after the notes to accounts, you will come to understand what's there actually inside happening in the company. Okay. With respect to subsection 4, application of CRR, for which purpose you can use it? Just now we have seen. For issue of fully paid up bonuses. Okay. Shall I continue? Section 56, transfer and transmission of shares. So from X, it goes to Y. This is transfer or transmission? This is transfer or transmission? X is aligned, Y is also aligned. This is transfer. From X, after X death, goes to X son. Guys, okay, please tell me to whom it will go? To the nominee. So X son is the nominee. We will call this as transmission. There's one line or one phrase you can attach to. Transmission is nothing but operation of law, which means what the law says, do it. Transfer. If X is willing to sell, Y is willing to buy, which is happening between two interviewers. Usually we use this term, two interviewers. Inter means what? Between. Viewers mean living. Between two interviewers. Okay. So transfer and transmission of shares is the same logic for both the case. Whether it's transfer or transmission is the same logic. Actually, what happens, especially in the case of physical shares, only we'll talk about this transfer and transmission because if it is demat shares, it's just directly going to happen because it will not go to the company. We are talking about the company point of view. We are not talking depository's point of view. Okay. So what happens is X wants to transfer the shares to Y. Okay. Who holds the share certificate? I'm talking about physical shares. So who holds the share certificate? X will hold the share certificate. Along with that, this person X will give a transfer form. To whom? To the company, which means what? To Y through Y to company. So when it goes or when the company receives it, company will check who has given this, X or Y. If directly X has given means no issues, they'll be transferring. If it comes through Y means company will check whether X has given that. உங்களுக்கு தெரியாம உங்க சைடு நான் போட்டேன்னா போச்சுடி. So they'll go for a cross check whether company has received through X or through Y or directly from X. Okay. So what to register? Transfer of securities for which company is applicable? Having share capital. Okay. It's nothing but interest of a member means we'll talk about not having share capital, contributors. Requisites, what do you need to have? A proper instrument of transfer. Usually it's done in SH4. It should be stamped, dated, and executed between transfer and transferee, and it will have the basic contents. Who is the transferee? The transferee's name, address, and occupation. Who has to deliver to the company? Please make a note by the transferor. If not, the transferee can proceed. Who has to give it? Transferor only. Within how many days? Within 60 days from the date of execution, he has to enclose the certificate also. If he does not have the certificate, which means certificate is not given, but the letter of allotment of security is given, means that letter can be enclosed. Okay. Proviso. If the share certificate is lost or not delivered, the company will register the transfer on such terms as to indemnify. Or bond will be given. An affidavit like bond will be. Okay. With respect to subsection 2, the company has the power to register the transmission on receipt of intimation. Usually they'll give a death certificate and other things. Okay. With respect to subsection 3, in case of application made by the transferor, and if it is partly paid up shares, please highlight. X, the transferor, transfers the shares to Y. Now, the person X, being the transferor, directly gives the instrument of transfer and the share certificate to whom? Company. Okay. And now, after the company checks, it seems to be a partly paid up share. See, in case the company makes the record where Y's name is taken for record, then who is liable now? Y becomes liable. Y becomes liable. So what the company does here is, it will give a notice to the transferee. இந்த மாதிரி ஒரு இது ரிசீவ் ஆயிருக்கு உங்க நேம்ல ட்ரான்ஸ்ஃபர் பண்ண சொல்லி பண்ணிடலாமா அப்படின்னு சொல்லிட்டு ஒரு நோட்டீஸ் கொடுங்க. Okay, you have to reply to that notice within how much? How much days? Within 2 days. If no notice is replied, then it will be considered as no objection, deemed to be not object. Okay. Then timeline to issue share certificates often repeated. One word like Sakmalna. Subscribers to memorandum of association with respect to any allotment of any of the shares 2 months from the date of incorporation or 2 months from the date of allotment. Transfer or transmission 1 month from the date of receiving the instrument or intimation of transmission. Any allotment of debentures means 6 months. See, this subsection is separately asked, and even you can expect this is 1 mark. Objective questions are one. Okay. Application for allotment, transfer, or transmission, unless prohibited by law, yes, you can directly proceed. Sometimes law will be or court will be holding the shares. You should not transfer or something. Especially this will happen in the case of promoters. The promoters will not be allowed to transfer the shares. Okay, it will be like locked in. The shares respect to subsection 5, transfer of security of the deceased person by his legal representative. Yes, see, X is no more now. Who holds the shares on behalf of X? X son. But what X son senses here is he doesn't want to hold the shares. He wants to sell the shares to Y. Yes, he can do it. Even though not transferred in his name. See, transfer of security of the deceased person. Who is the deceased person? X. Who can transfer? By the legal representative. Who is the legal representative? X son. Yes, they can do it. Applicable even if the legal representative is not a holder. He has the rights to hold, but he is not holding the shares because it's not a transfer. Okay. This is still valid as if he has been the holder of the shares at the time of execution. Okay. With respect to subsection 6, if above provisions are not followed, then the company and officer in default will be liable for a penalty of 50,000. With respect to subsection 7, liability of depository, yes, there is an intention to defraud the person, respective person, then it attracts penalty, which means criminal liability 447 and liability under Depositories Act also. It's not only we are following Companies Act, we are following Depositories Act. Is it okay? Without prejudice. What do you mean by without prejudice? ஏற்கனவே கம்பெனிஸ் ஆக்ட்ல தான் பெனால்டி போட்டாங்களே இங்க அப்படி இல்ல அங்கேயும் பெனால்டி போடும் இங்கேயும் பெனால்டி ஓகே cases of transmission in the case of death legal representatives will be the right person. In the case of insolvency official receiver will come. In the case of being lunatic then a court will be appointing an administrator. Okay, shall I take over? Forced transfer. So circumstance where we check whether a forged instrument is presented for registration. What do you mean by forged instrument? Signed is forgery. Forgery sign. Okay. So what the company will do here is company's action or company moves. It will write to the transferor and it will ask for a no objection certificate. See, we have received our instrument. It looks like a forged instrument, like the sign is not the right way. Is that you who are transferring the shares? So it will be asking in a return manner. Yes, and after that it will be checking whether the original owner is continuing to be the shareholder or the company is bound to restore the name. Okay. Either it will be transferring or not. Okay. So it becomes nullity or what? Okay. Nullity means what? The instrument will not be valid. That's what we call as nullity. And company's liability in case the share certificate are issued and the shares are sold to an innocent purchaser, means the company is liable to compensate the purchaser. Please highlight. See, it's the company's duty to check whether the transfer has to be done or not. If the company is not checking, means whose liability is that? Company has to bear the liability. Okay, now let me repeat this line. If the share certificates are issued, on whom? To the respective transfer. See, looking after this as a post transfer, it's been transferred and the shares are now sold to an innocent purchaser. Okay, X is the original owner. Okay, Y has got the post signature and that's been produced to the company. And company without checking, the share certificate are issued in whose name? Y's name. Now what Y is doing is, Y is transferring to an innocent purchaser Z. We could have mentioned purchaser, right? Why we are mentioning innocent purchaser? Because Z was not having this knowledge. So what Z was thinking? Y was holding the share certificate. So whose shares is this? Prima facie. If I hold the share certificate, you see, I hold a 500 rupees currency note in my hand. What do you think? I take a currency note from my purse, from my wallet. What do you think? You think it's my money. Okay, it's not written anywhere by Yamuna or something like that. But it's my money because it's a prima facie evidence. Likewise, why is holding a share certificate and that share certificate clearly mentions whose name? One name itself. Because the company has transferred the share certificates. Okay, it has given the share certificates. So Seth thought it was whose share? Why share itself? So now, that's why we call this Y as innocent purchaser. In this case, who is liable? Company is liable. Company is liable to compensate the purchaser on refusal of registration or true owner applies for the name. Who is the true owner? X is the true owner. Okay. And yes, they can recover the liability from the person who lodged the post answer. Who can recover? Company can recover. Okay. Forced to transfer in the case of joint holding. Yes, usually it's void only. Forced means it's void only. Even if one signature, there are three joint holders. One is forged. Yes, it's forgery only. All the three should be a genuine signature, right? If anyone is forged, also is forged only. I request you to go through these cases. Section 57, with respect to punishment for personation, deceitfully, which means uh, what inducing you, like personage, and obtains or attempts to obtains, which means inducing you to, as an owner of security or interest in company related to share warrant or any coupons, there will be a punishment for imprisonment 1 to 3 years, or fine 1 lakh to 5 lakh rupees. This is also often repeated. Refusal of registration in case the company is not registering, the refusal of registration, and you can appeal against that refusal. That's covered under section 58. What is the procedure followed by the company? Here, the company will be sending a notice of refusal to whom? See, when you give the transfer instrument, the company need not immediately transfer. It is having a doubt whether it's a forged instrument or not. So it will not transfer immediately. Okay, it will not make the records immediately changed. So what it will do is it will send a notice of refusal to the transferor and also transferring or other related person. Who's other related person? In case of transmission. Okay, giving intimation of transmission. Okay. This is in which case applicable? Transfer with respect to securities. And what's the nature of the company? Please highlight private limited company by shares and where the power has to be given in articles of association. Only in those companies applicable and within 30 days only it is applicable. Okay. With respect to subsection 2, in case it is public company means it is freely transferable. So you need not ask the question who is this wife. In the case of private company, you need to ask because it's a closely held company. Public company, not an issue because one of the main feature itself is freely transferable. You can directly proceed. And proviso, in case there is any contract or agreement between two or more persons with respect to this transfer of security, it shall be enforceable as what? We follow Indian Contract Act as a contract. Okay. With respect to subsection 3, yes, you can appeal to tribunal against refusal. Who shall appeal? Transferee, because I'm getting the benefits, right? You're transferring to me, you're the transferee, I'm the transferee, you're transferring to me, means I'm the beneficial owner hereafter. So I will get the rights to appeal against the refusal. Okay, if notice sent within 30 days from the date of notice means if no notice sent is within 60 days from the date of instrument of transfer, you can do it. Okay. So you can wait till that date. With respect to subsection 4, you can appeal to tribunal against refusal without sufficient cause. Yes, for who? For public company. This is who can appeal. The transferor can appeal. This section, who can appeal? Company can appeal. Okay. Who has to appeal? The transferee, no, not transferee, but public company. If intimation received within 60 days and no intimation received within 90 days. Okay. With respect to subsection 5, yes, what the tribunal will do. Either the tribunal will dismiss or it will give an order. What order it can give? Either direct to register or that is within 10 days it has to register or direct to rectify the register. Which means what? As usual, take it back. The same. And direct a company to pay damages. If they are not following the things, then it will be a contravention provision following with imprisonment 1 to 3 years and fine 1 to. Okay. With respect to section 59, rectification of register of members. Yes, you can appeal to the tribunal. Its applicability with respect to entry, not only for entry, even the omission also. Okay. If the right is given for the company to enter the record, it is the right given to omit the record on a no. Enter the record is different and omit the record is different. So in the case of default and unnecessary delay in any name, just applicable. Okay. See, I'm giving you to change the records, but you're not changing the name. Unnecessary, you're taking the delay. Okay. So in that case, you have to take moves, right? Who shall appeal? The aggrieved person or any member? Even the company has the right. Foreign members, debenture holders residing outside India, they can go for competent court. What do you mean by competent court? Our laws are different, foreign laws are different. Here we say, for related to company, here we say company, national company law tribunal. For them, there will be a different court. That's why I say in general as competent court. But not all the courts will be competent. It will be specified by the central government's notification. Okay. Then what's the tribunal move? Either dismisses the same thing, not repeating. With respect to subsection 3, no restriction to the right of the holder of securities to transfer and any person acquiring the shares. They'll be getting the entitlement to voting rights unless suspended. See, X is transferring to Y. The transfer has not taken place. Now the GM date has come, general meeting date has come. Who has the right to vote? This person, details are there in the record. Only this person is meant to vote. He cannot, that is, he's entitled to vote unless suspended by an order. Probably if there is a case proceedings going in the tribunal and the tribunal says, hold this one means, which means they will be clearly mentioning he will not have the right to vote means it will be voted. It will be suspended. Else it will not be suspended. Okay. Yes, you can apply to the tribunal in contravention with respect to transfer of securities. Yes, please make a note. This will be followed not only from Companies Act, we have to follow SERA Act, SEBI Act, Companies Act, and all other related laws. Who shall apply? Depository or depository participant or holder of security, even SEBI. Please highlight, even SEBI. Okay. And the tribunal may direct the company or depository to set right the contravention and rectify its register of records. Section 60 we have discussed, Section 61 we have discussed, and 64 also we have discussed already in the earlier topic. Okay. Sections 47 dealing with voting rights. Please make a note of it. Voting rights follows from Section 43, Section 50, subsection 2, and Section 188, subsection 1 related to all voting shares only. Subsection 1 says you get a right to vote. Who? Every member. Don't write in a shareholder. Every member will get a right to vote. Every member of which company? Company limited by shares. And also he should hold equity shares. Because we have two types of voting rights. One is voting by shares and one is voting by vote. Voting by shares means I hold one share. I get one vote. I'm a shareholder. See, I'm not a member. I'm a shareholder. I get one vote. This is one share, one vote. Okay. Or I'm a shareholder. I get one vote. Okay. So voting by rights and voting by vote. Voting by vote is voting right on a poll shall be in proportion to his shares in the paid up share capital of the company. I hold 1,000 shares. How many votes I get? In proportion to my shares. I get 1,000 votes. Okay. Here, every member will get a right to vote. Subsection 2, this is with respect to voting rights of preferred shareholders. Only based on applicability only, which means if his rights are directly affected, please highlight. If his rights are directly affected, then he'll get the right to vote. First point. Second point, when there is a resolution is being passed for winding up of the company or anything related to repayment of preference share capital. See, one case we were checking with unredeemable preference shares. So the company is not in a position to pay. So the company is deciding what it can do it. So in that case, and reduction of the equity of preference share capital. Okay. So nature of voting, nature of rights will be voting right on a poll shall be in proportion to the share in the paid up capital. Proviso, we have to maintain this ratio. We'll check with equity shareholders and preference shareholders, their voting rights will be equal to paid up capital and paid up capital. So this will be respect to paid up capital. Proviso, please highlight, this is often asked, repeated one. If there are arrears of dividend for 2 years or more, then the preference shareholders will get a right to vote on all the resolutions placed before the company. When the preferred shareholders get the right to vote only in these two circumstances. But what they say in this proviso here, if the company is not paying the dividend, it's mandatory for the company to pay the dividend. If the company is not paying the dividend, which means it has arrears of dividend, then for 2 years or more means continuous. 2 years or means, then they'll get the right to vote on all the resolutions placed before the company. Probably this will make the definition for holding and subsidiary company in a different. We have discussed over there. For a subsidiary company, we have to check the voting rights. Okay. Then we'll continue. Section 48. Variation of shareholder rights. You cannot vary actually. If you are varying means you will be defining this as different class of shares for class A share, class B shares, and so on. Okay. So condition for variation when it is applicable when the share capital is divided into different class of shares. Because whatever changes you make, whatever decision you do it on uniform basis. So you cannot change as it is. Okay. And the consent should be there in writing. From whom? You have to get the consent from 3/4 of the holders. Also, special resolution. Okay. In consent in writing should be from 3/4 of the shareholders, and you have to get a special both. Okay. Related to what variation you are making, related to MOA and AOA, what are the changes are there? And in case is not there in AOA and MOA, then such variation is not prohibited with respect to share options, but you have to check whether it is provided in the Companies Act. Okay, if it is not provided, you cannot do it. You cannot override Companies Act. So if variation by one class of shareholder affects the rights of another class of shareholder, please highlight that the consent of such other class of shareholders is also required. Okay. With respect to subsection 2, we can apply to the tribunal applicability of whom in case not less than, see, this is less than, this is not less than 10% of the holders not giving the consent, which means what? More than 10% are against it. So in that case, or no special resolution is passed in favor of it. So in both the cases, you have to go for applying to the tribunal. So apply for what? To cancel the variation. Not applying to get the variation, applying to cancel the variation. Okay, please highlight applying to within 21 days. Who can apply? Probably the person appointed will be there and he can make the application on behalf of the shareholder. It's not like each and every shareholder making the application. Put together, one person will be representing it, okay, making the application. With respect to subsection 3, tribunal's decision is binding on the shareholder. With respect to subsection 4, file a copy to the registrar. So who will file? Yes, the company will file within how many days? 30 days. And whatever you make, you have to make in uniform basis. This is directly dealing with section 49 saying that calls on shares. That's why we divide as different class of shares. Okay. If you are making one call for 2 rupees, you say this is first call and second call, right? One call money as 2 rupees. This has to be made uniformly for all the class. For example, I've named this as class A. If you are making share call for 2 rupees means 2 rupees for all the shares in class A. If there is another class B, okay, you are making for 1.5 rupees. It has to be made uniformly for all the shareholders in class B for 1.5 rupees. You cannot make different variations over here. Okay. Okay. Then section 50, company to accept unpaid share capital, although not called up. Yes, even though not called up, but as a shareholder, I'm willing to pay because I think, see, it's my liability only. If I'm not going to pay today, tomorrow, if the company makes the call, I have to pay. So let me pay today itself. If I think in that way, yes, company can accept the unpaid share capital, even though non called up. But only articles of association authorizes it and it can be whole or part of the amount remaining. Okay, for example, from this 7 rupees, 3 rupees is there, but I'm willing to pay this completely 3 rupees, yes, I can do it. Or I'm willing to pay 2 rupees and I will pay the remaining what? When it is called means I can do it. Okay. Yes, please highlight often asked. Subsection 1 is not that much important. Subsection 2 is very important. You can make the payment, but you're not entitled to the voting rights until the amount has been borrowed. This is uniformity. If you give the voting right for Mr. X of class A, you have to give the voting rights for everybody, but everybody has not paid the amount. So if everybody has paid the amount, please you can give. That's what uniformity is. Okay. So please make a note. This is very, very, very important. Make it as a case law. Okay, practical problem. Yes, this is a normal. 51 payment of dividend should be done in proportion of the amount paid upon each share if articles of association authorize. Then we'll go for section 65. Unlimited company can to provide for reserve share capital on conversion into limited. We have discussed this already regarding the uh, conversion case. When we are converting from unlimited to limited, who will be worried? Let me just recall those provisions. I'm converting unlimited company to limited company. Who will be borrowed? Creditors will be borrowed. So what we'll do is we'll reserve the share capital. What's reserving the share capital? 7 rupees paid up. Remaining 3 rupees, probably I may not reserve the full amount. From this 3 rupees, I may be reserving 1 rupee. When this 1 rupee will be paid? When I have to pay to the creditors. At that time, I'll call the money and give it to you. Which means I'm reserving the share capital, the unpaid value. So, in this 3 rupees, if 2 rupees is being called, it means the creditor will be very strong enough that, okay, I have that 1 rupees in that account. I'll get it. Okay, so that's the highlight. Let me come again this line. Unlimited company to provide for reserve share capital, which means reserving the share capital on conversion into limited company. Okay, shall do either or both of the following. What it can do? Increase the face value of share or provide a specified portion of its uncalled share. What second one I discussed? What's the first one? What's the first one? Second one is what I discussed. See, from the 10 rupees, 7 rupees is paid, 3 rupees is not paid, I hold 1 rupees, 1 rupee. What's the first one? For example, increase the face value. For example, 10 rupees is the face value of the share and it's fully paid up. What happens? There is no liability for the member. There is no liability for outsider. What I do here is I increase the face value to 12 rupees. When this 2 rupees will be called, and I keep this as reserved. Reserved. Okay. So for which purpose I will be using it? When the creditors are in need. Okay. So I can increase the face value of the share. Okay. Else I can specify the specified proportion of the unpaid value. Is it okay? So, such subject to no part of the increased capital or specified call of capital shall be kept. Okay. So it's under condition basis. When I can call for when the company is being owned up. Okay. 67th section. Restriction on purchase by company or giving loans by it for purchase of its own share. Company, there is a person X who is the managing director or any director. There's a person Y who is an employee. Can the company itself give the loan to the director and employee? No, under certain circumstances. What subsection 1 says is, it's a very wider section, says no company, please highlight this word, no company, section 1, sorry, subsection 1 is a restricted section, no company, which is limited by shares or guarantee and having share capital, shall have power to buy its own shares unless the consequent reduction of share capital, which means what? Only can go for buyback of shares. Okay, buyback of shares, you cannot call it as purchasing its own shares. It's buying back the shares. Okay, no company shall have the power to buy its own share unless with respect to consequent reduction of share. Not only that, it cannot give financial assistance. It's applicable for a public company. What type of assistance? Directly or indirectly, you are giving loan or you are trying to give a guarantee or any provision of security or any such case you cannot do. What is the purpose? See, you say that example for ESOP, Mahindra and Mahindra is selling. See, have you ever thought probably the shop cleaner will be buying the shares of Mahindra? See, you'll be thinking, ஒரு நாள் வேலைக்கு ஒண்ணும் இல்ல இப்ப எப்படி நான் ஷேர் வாங்குவேன் it will be thinking, right? So what Mahindra, for example, okay, it's not actually happening. So what Mahindra think is, I will give you money, you buy the shares. So it looks like as if Mahindra has given the ESOPs. Okay, it will look like some internal politics is happening. As if Mahindra is giving the supporters like. But what the outsiders will see, the Mahindra is giving support and the employees are getting the ownership. But actually, what is happening means what it is supporting or it is hiking the market share. That should not be done. So I should not guide you to buy my own shares. I should not provide for assistance to buy my own shares. What type of assistance? Financial. Financial means a wider angle. Loan, guarantee, provision of security. For what? Purchasing or subscribing my own shares in my company. Not only in my company, also in holding company. Okay? Also in holding company. But this is not applicable. This provision. Providing financial assistance not applicable. Which company? Banking company. See, it's the ordinary course of business itself is that only, lending of loan only. So for banking companies, not applicable. If there is a scheme approved by special resolution related to fully paid up shares where the shares held by employees or trustees for the benefit of the employees not applicable. And please make a note of the C point, often repeated question. Probably you may get this as a whole question or the C point alone may be asked. By way of loan, yes, you can give. See, what was the first subsection and second and third one? They are saying you should not provide loan. But what the C says is, you can give loan. How much? You check the salary or the wages of the employees. And to what limit you can give? To 6 months. If employee Y is earning 10,000 rupees salary and you are giving the ESOS plan for him, he is thinking where I'll get the cash. The company says, I will give you. How much? Maximum of 6,000 only. See, this is not more than. Not more than 6 months salary or wage. So not more than 60,000 it can give it. And who are those eligible persons? Employees. It is excluding directors and KMP. Please make a note, to directors is not allowed. To employees it can give the loans. Please highlight. Now tell me, executive director is an employee or director? As per this definition. See, for each and everywhere, for sweaty kitchen, we have a different definition. For employee, ESOP plan, we have a different definition. Here, executive director is an employee or director. Don't get confused. His name itself carries the name director. So that's why he's a director. Okay. Purpose for fully paid up shares only, and nature will be the beneficial owner. Okay. And it should be disclosed in the board's report. Okay. That the voting rights not exercised directly by the employees in respect of the shares to which the scheme relates. You understand this small line? Kindly go through this line. There's two lines. That the voting rights should not be exercised directly by the employees. Okay. Which means what? The employees will not directly get the voting rights in respect of the shares which the scheme relates. Already, please make a note here. X, Y, Z are all put together, are already members of the company. There is a general meeting held on behalf of this plan, because whether loan can be given or okay, whether loan can be given, whether the ESOP can be given, everything is done. So whenever we talk about the annual general meeting, the extraordinary general meeting or annual resolution will be passed. Who will pass the resolution? So far we have said that X being a member have the right, Y being the member have the right, Z being the member have the right. But this resolution is passed on behalf of issuing shares. X is an employee. What the employee will do? He will vote in favor of that only, right? So X is not allowed to vote. Now read this line. Now read this line. That the voting rights not exercised directly by the employee in respect to which the scheme relates. So if this person X is one of the beneficiary in the scheme, means he is not allowed to vote. See, this is not only applying in this case, in most of the cases, இந்த ரெசல்யூஷன் பாஸ் பண்றனால எனக்கு நல்லது நடக்கும்னா நான் என்ன பண்ணுவேன், எனக்கு ஃபேவரா இது பண்ணிப்பேன், அது பண்ணக்கூடாதுன்னு சொல்லுவாங்க. Conflict of interest, I don't know, you can write it here. It may, if allowed, it may give conflict of interest. Okay. So in case you're going to provide loan or any assistance for the employees, this is going to affect the redemption of preference shares. Means subsection 4 says it will not affect the redemption of any preference shares. Is it okay? Contravention. If not following this, company will be liable to a penalty of 1 lakh to 25 lakhs. Okay. Usually we say 1 lakh to 5 lakhs or 1 lakh to 3 lakhs. But in this case, it's 1 lakh to 25 lakhs. Please remember. An officer in default will be liable for a imprisonment up to 3 years and fine 1 lakh to 25 lakhs. So shares and related concept over, we have to go for debentures. Yes, can you please go through debentures? When we go for two types of capital, one is equity capital. So far we were discussing till equity capital. Now is debt capital. When we go for debt, there are so many forms of debt. One is external commercial borrowing. We have debentures. We have bank loan. We have public fixed deposits. So in that case, we are going to discuss all debentures. Okay. So what are debentures? It's a debt capital and it's a long-term borrowing. So nature, here debenture holders are considered as creditors. No voting rights will be there and certain percentage interest will be given. Not interested, interest will be given and they'll be issuing this as a series of debentures. please highlight. Usually it will be containing this clause called as pari passu clause. What do you mean by pari clause? Pari passu clause means date is not the main theme here, which means issued at different dates, they carry the same rights. Pari means at par, okay, with respect to time. They may be different chronological dates, but still we consider them as equal in rights. Okay. Types we have redeemable and irredeemable. Irredeemable is something what we call as we are not redeeming. So we call it as perpetual debentures. Okay. Irredeemable is we can say this as secured or unsecured, convertible to equity shares, like partly convertible or wholly convertible or non-convertible at all. Registered and barrel. This is the only one thing extra we are going to learn here. Registered debentures means your name will be there in the registry. Barrel debentures means your name will not be there. So X holding the debentures of a company, transferring to Y, transferring to Z, transferring to A. Anybody can transfer because it's barrel. Barrel means what? Holding no name. At last, it is to A. Then directly A at the time of redemption. Directly A, what you can do? You can directly go to the company and redeem the debentures. Okay, barrel debentures. So that's a short comparison between shares and debentures. You can just have a look bit later. I'm directly going for section 71. Shall I take over? Section 71, subsection 1 says a company can issue. That means, see, you learn this way. The company may issue. May issue means what? Yes, it can issue. Okay, there's nothing called as may not issue. Okay, may issue debentures with an option to convert into shares either wholly or partly at the time of redemption. And there's a proviso, it should be approved by the shareholders by special resolution. Subsection 2, you cannot issue debentures with voting rights. With respect to subsection 3, you can issue secured debentures but subject to prescribed terms and conditions. Like means securitized, probably collateral security is given, charges created, and so on. With respect to subsection 4, very, very important, creation of debenture, redemption, reserve. From where you create it, what is the source here? Out of profits available for payment of dividend. So you know this, when we say interest, it's a charge on profit. How we define the interest? Charge on profit. Okay. An application only for redemption of debentures. For what you use this? Why you create this DRR? Only for redemption purpose. See, the name itself is debenture redemption reserve. What is this? R stands for debenture redemption reserve. So this reserve, see, whenever you have a name for the reserve, that name is very specific. So this reserve is having the name debenture redemption. So you're going to use it for redeeming it. Okay. With respect to subsection 5, condition for appointment of debenture trustees. That's the highlight one. Okay. When we say debenture, we have defined the debenture as long-term borrowing. Okay. How far equity capital, which means equity and preference share capital, is playing a role? Some companies will be having a very small amount of equity capital, so 1 lakh or 2 lakhs or some 15 lakhs or 20 lakhs. But the debt capital will be very, very high. Especially debentures will be high, very high. Debentures and deposits. Deposits also second only. Debentures will be very high. So whenever we talk about debentures, there is an appointment of debenture trustees. It's a condition that you can appoint it, but not in all the cases where there are exceeding 500 for the subscription of the debentures. Okay. So when a company issues a prospectus or makes an offer or invitation to the public or to the members, exceeding 500 for the subscription of his debentures means then it is mandated that they need to have a trust called as debenture trust, and the trustees running will be called as debenture trustees. Okay. And it will be given what are the conditions governing the appointment, and everything will be disclosed. Okay. When they have to be appointed, please highlight, asking the question before such issue, not after issuing. So probably when you go for giving this prospectus itself, you have to give all the details about the debenture trustees. Okay. With respect to subsection 6, what is the role over there? Yes, obviously to protect the interest of the debenture holders and address the grievances. In case they have any grievances, they are not okay with the terms, then you have to address it. And void in nature. Yes, please highlight. Something is said like debentures or any contract is there entered between the debenture holders and all. Exempting, please highlight the second one, exempting a trustee or indemnifying him against any liability means that will be void. So, as per the provisions, as per the act, you have to follow. If in the agreement you are writing any clause, actually, we'll say this term called as contracting out. Contracting out means you're not following as per law. Law, see, as the nature of the trustee, what is your role? You have to protect the interest of the debenture holders. But you're writing or you're framing some lines in the agreement in such a way that you're taking your liability from outside. You're taking the liability, which means or you're exempting the trustee or you're indemnifying him. Indemnifying means protecting him. See, trustee's role is to protect you. Your role is not to protect the trustee. Trustee has to protect you, right? So in that case, if any clause is added, which means it's contracting out, which is contracting his liability out, means then it will be void. We say this as void ab initio in general. Okay. If it is given in law, means you should not do, which is void ab initio. Okay. Failure. On which cases it will happen, Pa? Breach. In which cases it will happen? Failure to show the degree of care and due diligence. He's not taking much care about the beneficiaries. Okay. Proviso. Liability is subject to the exemption agreed by at least three-fourth of the majority holders. Three-fourth of the holders, not the holders, value of the debenture holders. Okay. So this one you have to check. Then with respect to subsection 8, payment of interest and redemption as per the terms and conditions. With respect to subsection 9, you can apply to the tribunal. So you can give a petition to the tribunal. Probably the assets of the company are not sufficient, or probably they will not be in a position to repay the amount in that case. Who can file? You need not file it. Debenture trustees are there. They will file it. Okay. And what the tribunal will be doing after hearing all the things, agreements or arrangements are between the two persons. After hearing the company and other interested person, it will order for imposing restrictions, whether they can carry over the liabilities or not. Okay. With respect to subsection 10, failure on redemption or pay interest, you can apply to the tribunal. Who can apply? Debenture holders, any or all of even the trustees. Okay. So what the tribunal will do? The tribunal will order for redeem on payment in principal and interest. That one is omitted. 12. A contract with the company to take up and pay for any debentures may be enforced by a decree for specific performance. What do you mean by specific performance? Means what I got it from you. Say I'm the company. Company has issued the debentures. What the company has got it for the debentures? Usually cash. Okay. In terms of cash. Okay. That has to be written. That's what you call as specific performance. But what happens is sometimes company will be saying you paid cash, we issue debentures. But we are not in a position to issue debentures. Sorry, cash, which means redeem the debentures. Instead, we'll give you shares. Okay. What the shareholders, sorry, what the debenture holder X, Y, Z says. Z may be saying, okay, I'm going to get the shares of the company, let me get it. What X and Y says is, no, I want cash only. Now leave this line. I'll file a decree. Decree means filing a case. Litigation proceedings, decree. For what? Specific purpose. What's the specific purpose? Returning the money. Okay. So contract with the company to take up and pay for any debentures may be enforced by how? By a decree, which means what? You have to proceed as a case. File as a suit. Okay, else you cannot do it. With respect to subsection 13, yes, central government is empowered to prescribe the procedure for securing the debentures. Form of debenture trust deed will be there. What are the procedures to be followed? How much you have to create the reduction reserve? Probably we usually do this 10% annual basis for 10 years or 15 years or whatever is other related times. Shall I take over? Section 72. Yes, power you have the rights to nominate. Who can nominate? Every holder of securities. What do you mean by securities? Shareholders, equity shareholders, preference shareholders, everybody. Okay. Even if I hold a bank account, I can nominate. So even I'm going to hold a basic amount, I can nominate. Means this is I'm having my interest on the investment. Okay, it's not normal money, it's an investment. So I can nominate. Okay. Then at any time, reason for vesting in the event of death. Okay. With respect to subsection 2, in case of joint holders, nominate together. So in the event of death of all the joint holders, you will get it. Okay, you get the rights to hold it. With respect to subsection 3, entitlement of all rights, yes, nominees as discussed in the above case, whether they can include or not. Sometimes nomination will go as percentage weightage. If two nominees are given, 50%, 50%, or 80%, 20% will be given in this order. So nomination may be varied or cancelled or whatever it is. So how far they are entitled to that rights will be mentioned. In case nominee is a minor, yes, they can be done, but in case during the death of the minority, they have made the nomination means it will be not directly going to that minor person. Okay, it will go through the court. Probably till he becomes major, the court will be holding the rights. Okay, so this will happen, and else a guardian will be appointed. Okay, we'll be calling for a case if that person becomes a lunatic or something like that. We call friend. Okay, if it is this person is a minor, means we call guardian. Okay. Case to case it changes. And miscellaneous, likewise, usually 10 years for redemption. Sometimes we take it for 30 years. In which case, one related to infrastructure projects, finance, debt, and all. Probably sometimes ministry or department of any central government, RBI or National Housing Board or any other cases, they will be giving some notifications. And charge will be created. How the charge can be created for debentures? Either on the company's assets or subsidiary company's assets or holding company assets. Okay. Disqualification of debenture trustee. Actually, this is not the heading. Please correct it. It's not the heading. If there are more than 500 numbers, we need to have a debenture trustee and trustee. So remember the very first point we were discussing. If they are issuing the prospectus or the advertisements, etc., to more than exceeding 500 numbers, means you have to go for. And the purpose is for redressing the grievances and all. Liability of breach of trust will be there. Probably you can strike out this para. I think I have discussed everything. Probably this is an error. You can strike it off. I have discussed everything. Debenture redemption reserve. You check what is the debenture outstanding. Please highlight outstanding debentures. Okay. And the reserve has to be created with 25% of the outstanding debentures. Who need not create this DRR? Often repeated, who need not create this DRR? All India financial institutions going for public issue or private placement need not issue. That is, need not create DRR. Banking company need not create. In case if it is a non-banking financial institution and is registered with RBI means 20%, 25% of public issue alone may be created if it is public issue. If it is going for private placement of debentures means it need not create 0%. It need not create. And if it's giving the debentures to financial institutions, means need not create. See, non-banking financial companies issuing the debentures to financial institutions means need not create because their role itself is that only. They have to take risk. Okay. And when they have to invest this amount, invest before 30th April, strictly less than 15% as of 31st March. So it should not be more than 50%. See, if you are able to invest more than 50% each and every year, means why you go for debenture? Please think in that. என்னால வந்து வருஷம் வருஷம் 10 லட்சம் ரூபாய் சம்பாதிக்க முடியும்னா ஏன் 5 லட்சம் லோன் வாங்குனீங்க? That's the concept. Okay. See, you need not buy loan, right? You need not see what is the intention of buying the loan? Because you need money, you need for investment purpose. Now you are in a capacity to earn more, much more money. Then why you need to pay the interest and all? Not necessary. அதெல்லாம் ஏமாத்து வேணாங்களா? Okay. So deposit where scheduled bank, no charge will be created. Please make a note, often repeated, no charge will be created. On which? On DRR. You are creating a reserve. You are opening an account. Usually we call this account as escrow account, which is used for this purpose. So probably for each and every year I'm depositing and I have almost deposited like 73 crores, for example. 73 crores. Just a number I'm giving. 73 crores. Okay. Now the company is planning for any other investment. It has to give guarantee or it has to create any charge. Company says, see, there is a 73 crore account in my company's name. You cannot use it. Okay. Because for what purpose are you using it? Redemption purpose. You cannot use it. This is an escrow account. See, account இருக்கறதெல்லாம் என் பணம் இல்ல. And that's why what we do is probably the company's name is ABC Limited. In case ABC Limited means ABC Limited, it will be given as debenture redemption reserve account. It will be named. If you are creating a capital gain account, it will be mentioned as capital gain account. If you are creating a share application account, it will be created as share application account. In the bank, a separate account has to be opened. It's a norm, it's mandatory. So you have created that account, you have opened that account only for what purpose? Using for this purpose. Now you want to create a charge, you cannot do it. If you create a charge also, it becomes void. Law says you cannot create a charge. What do you mean by creating a charge? உங்கள நம்பி எப்படி பணம் தர்றது? இந்த பேங்க்ல 73 கோடி ரூபா இருக்கு. See, that's what creating a charge means. We need security from you. And you have 73 crores in your account. See, that 73 crores is meant for some other purpose. How can I create charge on? Okay. So no charge, and also you cannot say it's a gain. Say I have earned so much and I have 73 crores in my account. No, it's not a gain for you. It's the money you brought in hand you do. So either you deposit in this way, or what you can do, you can invest in unencumbered securities. So probably you might be understanding also. And what purpose you can use it? Only for Ramshi. Yes, sometimes there will be a meeting convened by the debenture trustees. Probably not always is not mandatory because their role is to protect the investors only, so no other go. So if the shareholders, it's not the shareholder, debenture holders, at least 1/10 holding in value. If they write it, then you can go for meeting. Okay. So this is a very rare situation only. Over. Huh? That's it. But thank you. Thank you.